Hello, everyone, and welcome to AI and Fair Use in the Wake of Warhol and Copyright Office Draft Report. I am Samantha Sevis, and I am one of the membership committee chairs of the BHBA's Barrister section, and I am delighted to introduce our speaker, Amy Scala. Amy is a partner in the Los Angeles office of Mazzola Lindstrom LLP, where she practices litigation and transactional law in fine art, intellectual property, media, and entertainment. As a part-time lecturer at UCLA School of Law and past chair of the Los Angeles County Bar Association's Entertainment Law and Intellectual Property Committee, she frequently speaks on art law, copyright, and fair use. And before practicing law, Amy was a photo editor of Artforum magazine, and she currently serves on the board of Fulcrum Arts, a nonprofit advancing collaboration between art and science. Now, let's get started.
Thanks, Samantha, for that lovely introduction. And thank you to the BHBA and the Art Law Committee and our lovely chair, Sarah Conley Odenkirk. Her leadership has been really wonderful, and I'm so happy to be here with you all. I also want to thank our membership. I am greatly indebted to all of the members, the practitioners, the professors who are part of this community who have shared their knowledge about AI and copyright and these issues. I don't know that I would be nearly as well informed on these issues if it wasn't for the Beverly Hills Bar, and I'm just really happy to be able to pay it forward a little bit. So without too much more, I will start our presentation. So we're going to be talking about the Warhol case, the Copyright Office draft report, and the fair use doctrine in the context of the AI and copyright litigation that we're seeing coming down from the Northern District of California and a Delaware District Court decision in one case. And, so before we get too far along, I think we need to understand a little bit about the fair use doctrine in general and what the defense is. So, it's a defense, so it's an affirmative defense. The burden of proof is on the defendant. And I think that comes up a little bit in the Kadri case, as we'll get there in a little bit. But I do think that the burden of proof with respect to the fourth fair use factor in Kadri is an interesting question. But the fair use defense is thorny. It has been called the most troublesome in the whole law of copyright by Judge Leonard Hand in 1945. And I think that, troublesome is a great way to describe it. And I think that remains the case today, perhaps even more than at that point. So here are the factors here. I imagine that a lot of you know this, but just, in case, I want to make sure that we're all on the same page. Well, the factors are there and they need to be balanced. Fair use really is a flexible concept, as we learned from the Warhol case and from Oracle. While one factor may prove to be more important in other contexts than in others. Application of the factors requires judicial balancing, depending on relevant circumstances and, including significant changes in technology. And that is, again, the Oracle case, quoting Sony versus Universal Studios, or the Betamax case. So the first fair use factor asks about the purpose and character of the use. Is it commercial? Is it nonprofit? Is it educational? The first fair use factor also asks whether or not the secondary use is transformative. And we're going to talk a little bit more about that. The second factor asks about the nature of the copyrighted work. Is it published? Is it unpublished? Is it fact-based? Is it more creative, right? If a work is unpublished, it's less likely that a secondary user can make fair use of it. We learn from the courts that the right to release a work to the public for the first time is a right that the author holds that isn't easily usurped via the fair use doctrine. The factual versus more creative component, we're asking if there's a thin copyright. Facts are not copyrightable, ideas are not copyrightable. So how much of the creative expression is really there? And when we're talking about the works at issue in the AI cases, we really are talking about the heart of what the Copyright Act is intended to protect, these original, expressive, creative works. And then the fourth fair use factor, the third one, asks about the amount and substantiality of the portion used in relation to the whole. So how much is used? And what is used? It's not really a mechanical calculation. It's more about, we see that if you take the essence of someone else's creative work and use it for similar or the same purposes and compete with them, it's probably not going to be a fair use, right? And so I think in the Harper and Row case, we saw the Supreme Court tells us that, you can't take the heart of Gerald Ford's memoir, where he's like deciding to pardon Nixon, I think was the moment that the nation decided to publish, right? And so they really did take the heart of it, and that wasn't a fair use. The last factor asks about the effect of the use on the potential market for or the value of the copyrighted work. Is there substitution here? Can somebody use the secondary work, as a replacement for the first? And the fourth fair use factor, as we will see, is really crucial in understanding the decisions that are coming down about generative AI. So the first and the fourth factor, spoiler alert, they're the most important. And the purpose of the use is discussed a lot in Warhol. And this question of whether or not the secondary use is transformative. And this transformativeness test, uh, you know, really it comes from a law review article written by Judge Laval called Tort of Fair Use Standard, and was really cemented in copyright jurisprudence in Campbell versus Acuff Rose, which you'll all remember as the case involving Two Live Crew's parody of Roy Orbison's Pretty Woman. In Campbell, the Supreme Court interpreted the first fair use factor to include this question of transformativeness very clearly. Um, and they tell us to ask, whether or not the new work is, just merely supersedes the objects of the original, which comes from the Folsom versus Marsh case, or if it instead adds something new, right, with a further purpose or different character, altering the first with new expression, meaning, or message. And that's a pretty broad statement. And I think that the Campbell case doesn't really articulate whether or not we are thinking about the purpose of the works or the purpose of the secondary user. And I think that that's an issue that really comes up in Warhol. And then the fourth fair use factor is undoubtedly the single most important element of the analysis, according to the Supreme Court. And I think we're really seeing this factor do a lot of the work with respect to how fair use is being applied in the AI cases. So this factor is going to look like, as we talked about, the extent of market harm caused by the particular actions of the alleged infringer. And it asks, whether unrestricted and widespread conduct of this sort would result in a substantially adverse impact on the potential market for the original. So that's coming from Campbell, and they're quoting Nimmer. And it's important when we think about this factor to remember that there may be all kinds of market harm to a copyright holder from a secondary use, like a withering criticism of a movie that just kills the demand for it, right? That's market harm for sure, but it's not something that is actionable, for purposes of copyright, and undermining the fair use defense, right? It's the only relevant harm here is market substitution, and that's an important thing to remember. So in approaching fair use, and new technologies, the courts have sought to further copyright's basic purpose of promoting progress by striking a balance between protecting authors' exclusive rights on the one hand, and enabling others to build on those works on the other. And in the Grokster case from 2005, the Supreme Court tells us that the more artistic protection is favored, the more technological innovation is going to be discouraged, and that the administration of copyright law is an exercise in managing the trade-off. Now, that is, an incredibly difficult thing to do, and I don't envy the courts in their, having to deal with these questions and grapple with these questions. It's incredibly interesting, but it's also, really, really, really difficult to balance these competing interests. How much protection is enough to, let innovation flourish, but not kill incentive to create, new works in the future? How do we strike that balance? It's a real challenge. So we're in, you know, an art law committee panel here, and I am a practitioner in the art law space for sure. So outside of technology, in the arts, we see that this tension has really been embodied in the various legal disputes involving appropriation artists. Right. And while I wouldn't categorize Warhol as an appropriation artist, pop art for sure, I do think that the Prince case kind of, dovetails with those. But Jeff Koons, for example, he was, sued a number of times and he's relied on the fair use defense in those contexts. And somewhat more recently, about 10 years ago now, appropriation artist Richard Prince was involved in litigation involving his appropriation of other artists' works and his own work. And I think that, before diving into Warhol, we really need to understand the context in which Warhol developed, right? So Warhol is a Second Circuit decision that was appealed to the Supreme Court. It was affirmed, but the Second Circuit has played a large role in interpreting the transformativeness test and applying the transformativeness test in its first factor analysis. And so you might remember um, you know in 2000, photographer Patrick Carey published this book, Yes, Rasta, of black and white photographs of the Rastafarian community in Jamaica. And Richard Prince, being Richard Prince, created a series of works called the Canal Zone series in 2007 and exhibited them at Gagosian Gallery in 2008. So the Canal Zone series incorporates the images from Yes Rasta in more, or less extreme ways, right? So this is just one of the works from that series. And so if we look at that case, um, you know, in 2009, Carey sues for infringement, and in 2011, the district court, Judge Batts and the SDNY, grants summary judgment for Carey in favor of infringement. Prince's works are not transformative. They don't comment on or criticize Carey's originals, so they're not entitled to the First Amendment defense. And you know, what was kind of extreme in my mind as somebody who was viewing this at the time was that the SDNY ordered that all of Prince's unsold works from the Canal Zone series and all of the catalogs that were produced on the occasion of the exhibition at Gagosian be impounded and destroyed. That's not, I think that was the remedy that the plaintiff asked for. But as you'll see in the Kadri case, there, the court noted specifically, the Kadri court is telling us, like, look, you know, you don't need to stop doing what you're doing. You just need to pay for it, right? And so that's a little bit in contrast with what we saw here. And so I think that the Second Circuit, in ruling, in reversing and vacating the Carey decision, was responding in part to the extraordinary remedy that was ordered in the district court. And so the Second Circuit reverses and remands, and they say that, look, we need to look at all these works separately. We can't lump them all into one box and decide whether the entire series is fair use or not. That's not what we're going to do. We need to look at each individually. And once we've looked at each individually, then we see that, all except for 5 of them are fair use as a matter of law. And these 5 are going to be remanded to the lower court to decide whether or not they're fair use. So the Second Circuit also tells us that the appropriate standard to, apply the transformativeness test under the first fair use factor is, you don't need to be commenting on the original work. You don't need to be criticizing it. It doesn't have, it can be raw material for your new work. That's totally fine. And so the case settles in 2014. So we never know if, for example, Graduation, this one in the top with the figure with the guitar or the bass, that's Prince's work, and then on the other side is Carey's, right? So this is one of the works that was remanded for a determination of whether or not it was fair use. But in the aftermath of Carey, the Second Circuit, there was a lot of critics. Nimmer criticized the decision, and another appellate court did too, and criticized Carrier in particular, and the Second Circuit in general, as giving too great a weight to transformative use in determining fair use. And so it's against that backdrop that we get the Warhol decision. And the Warhol decision, I think, really does need to be understood in the context of Carrier, because it's the pendulum swinging, right? The Second Circuit was interpreting the transformativeness test, incredibly broadly to certain commentators, and decided to use the Warhol case as an opportunity to walk it back. So, there you'll recall Lynn Goldsmith. She's a rock and roll photographer, doing great work in the 80s, and um, had Prince in her studio in December of 1981. She took a series of photographs of him. And a couple years later, Vanity Fair asks her to license her picture, one of her pictures from that session, to give to an illustrator to create an illustration for the magazine. And and Warhol was that illustrator. He created this silk screen, this purple Prince silk screen. Uh, Goldsmith was credited, and she was paid a license fee. Importantly for this, the license was one time only, right? So it was limited. It was a limited license, and the scope was very clear. And Warhol ultimately created, I think, 16 works based on this photograph. So he plainly exceeded the scope of the license. I think that's also another piece of this that we really do need to keep in mind. So, you know, 2016 comes around, Prince passes away, and Vanity Fair asks the Andy Warhol Foundation to license an illustration um, for the cover, one of Warhol's Prince series. Goldsmith doesn't get credit, she doesn't get a licensing fee, she's not involved at all. She sees the magazine and is like, "Hey, that's my picture," and asks the Warhol Foundation for a license. Instead of licensing the picture, the Warhol Foundation sought a declaratory judgment in the SDNY, um, for a determination that Warhol's use was fair use. Right. So in the SDNY, we see that summary judgment for the foundation, Andy Warhol, is granted. Three of the four factors favor Warhol. And Goldsmith appeals, and the Second Circuit reverses. And they even mention Carey in this decision. They're reversing, they're taking this as an opportunity to really walk back, the broad interpretation of the transformativeness test that we saw. And I think maybe that was unexpected for the Warhol Foundation. I don't know, but I speculate. Anyway, the Warhol Foundation appeals, and the Supreme Court affirms the Second Circuit and says, "Look, the Andy Warhol Foundation's use in this licensing context is not transformative." And what we do see is that when reading the decision, the scope of the Warhol decision is really narrow. Um, the decision is limited to a licensing purpose for an illustration on the cover of a magazine. So, crucially, we don't get a determination of whether Prince's series of, I think, 16 silk screens of Warhol's series of 16 silk screens of Prince are themselves fair use, right? The Supreme Court never answers that question. So we really don't know whether the underlying works are fair use or not. What we do know is that in the context of a magazine cover and licensing an image for purposes of illustrating an article on the musician, we know that that is not fair use. But in the Supreme Court's decision, they tell us that different uses have to be considered separately, and that the same copying may be fair when used for one purpose, but not for another. And so it really does beg the question, was Warhol's original creation of these paintings fair use or not? And I think that sometimes that's not, considered when Warhol's being applied. Um, in addition to, a very narrow purpose and evaluating a very, very, very narrow purpose in this licensing context, we also see that the Warhol decision applies, they're only evaluating the first fair use factor. And so I think that that's playing into this as well. Some language that's really interesting from the Warhol decision is that we get a clear statement that uses don't turn on the subjective intent of the user, right? So what Prince was thinking when creating the work, or what the Andy Warhol Foundation was thinking when licensing the work, is irrelevant to this determination. What matters is an objective inquiry into what use was actually made, what the user did with the original work, right? And so when we think about that, it's very clear that, when we look at the magazine covers, side by side, the purpose there is almost the same as the Supreme Court defined the purpose. So we can debate about whether that's the right call, but it's the decision. And another thing that we learn from Warhol is that the opinion makes clear that it's concerned with the standard for transformativeness under the first fair use factor, subsuming the derivative work right. And that broad interpretations, or an overbroad concept of transformative use, is going to um, subsume the derivative work right. And it's necessary for the new work to comment on or criticize the original in order to be transformative, as that term is used in the first fair use factor analysis. Even significant alterations are not going to be enough if the use ultimately serves a similar purpose to the original, and may produce instead a derivative work and demonstrate the need for licensing, right? So this is a piece of the Warhol decision that I think is worth drilling down on, and is an important part of it going forward. Um, Given all that background, with the very narrow scope of the purpose of the use that was analyzed, and the fact that we're only getting a decision regarding the first fair use factor, not all of them, um, we see that Warhol going forward is being applied fairly broadly. And I think that that's an important thing to remember, because as practitioners, um, we want to keep in mind that maybe we should be you know keeping narrow Warhol in its narrow lane, instead of jumping to the language that's in there and then applying it more broadly, which I think is what is happening. Um, Shifting gears now to the Copyright Office pre-publication report. Um, the Copyright Office has been releasing reports. It's released 3 reports since July of 2024 on issues stemming from AI and copyright. So the first part was digital replicas, the second part was copyrightability, and the third is generative AI training. Um, and in large part, the reports evaluate and analyze the comments that the Copyright Office received in response to its notice of inquiry. So in 2023, in August of 2023, the Copyright published in the Federal Register a broad series of questions that it wanted comments on, in order to evaluate this novel issue, and develop its perspective. And so the report is a really interesting read. If you have some time, it's definitely worth taking a look at. But it's also worth pointing out the sort of interesting circumstances, surrounding its release. It's a pre-publication report, which, as highlighted at the time by Aaron Moss of Copyright Lately, issuing pre-publication or draft reports is totally not standard for the Copyright Office, and the release of this report was between two, pretty extraordinary firings that happened. So on a Thursday, the longtime Librarian of Congress, Dr. Carla Hayden, was dismissed. The report is released that Friday, and then that Saturday, the Register of Copyrights, Shira Perlmutter, was fired by the administration. And so, you know, given that the Copyright Office is a part of the Library of Congress, and Congress is obviously part of the legislative, is the legislative branch, not the executive. There is a tension there between the authority to actually do that by the executive branch, but that is a separate, fascinating question that I cannot delve into here. But for our purposes, it's important, to have that context because we don't know, the weight of this report is going to have going forward. It's really not clear at all. It could be, it could be pulled from the website tomorrow. It could be dramatically edited and revised. But, the report as it was published in May of 2025 tells us a lot. And I can't get into all of it. Again, it is really interesting reading, especially because it describes, so concisely the various positions of various stakeholders, who really have skin in this game, and their positions with respect to these issues. And I think that that's just so helpful, to understand these issues on a practical level. And with respect to fair use in particular, right? So the report is divided up into 5 parts. Fair use is just one. But when we look at what the Copyright Office is saying there, it's kind of no surprise. Um, in order to evaluate whether a particular model is transformative, depends on its circumstances and depends on the facts of the case, just like the fair use defense itself, right? We're never going to have, a boilerplate answer of, all models are fair use or none are. They all exist on a spectrum. And some systems are going to undoubtedly be transformative, while others are not going to rise to that level. Um, with respect to the market harm, as I was reading the report, this idea of statistical similarity caught my attention. And I don't know that the report uses that particular phrase, but it does sort of encapsulate something that's raised a few times. And so, I think that maybe going forward, and I haven't fleshed this out yet in my own mind, but I think statistical similarity may be worth thinking about as a way to understand and maybe bridge copyright principles and standards of infringement with the complexity of AI models, right? So if you this picture, which I saw actually in a Beverly Hills Bar presentation on AI a while back, is it really helped me visualize the process in a diffusion model where we're going from, static into an actual image. And so, the statistical similarities between original works and copyrighted work, and secondary works and ones that are output from AI systems, it is an interesting way of maybe thinking about this. In the Kadri case, for example, the court does note the relationship between copying statistical elements of plaintiff's books and how this is copying the creative expression embodied within them. So the court tells us that even though LLMs may only learn about statistical relationships, those relationships are the product of creative expression. So the statistical relationships in the organization of words in a book is, that is the creative essence of that book and is on a certain level. And so I think it's an interesting question to consider. Another aspect of the Copyright Office report that is really interesting is that the report really articulates this broader market dilution harm. And we see that it's a novel harm. It's not something that's really been evaluated in case law before, but it could very well be an actionable harm in at least in the the Copyright Office's view seems plainly relevant to the questions raised by the fourth fair use factor. So, moving along to the lawsuits that have been filed, right? And so, to give us a little bit of context here, fair use has been, you know, the way that disputes between technological innovations and rights holders have been resolved throughout our history. When the camera came out, although the Cerrone case was really questioning, whether or not photographs were copyrightable at all. I think it does it is a case that arises because of technological innovation and these tensions. But at the turn of the 20th century, we saw the player piano issue arise, and we get a case law on it, and then we get the 1909 Act, which addresses the issue squarely. Um, you know, Closer to our own time, we see in the 80s we had the Betamax case, right? The Sony case, and there, the VCR, the Betamax was fair use, and using it to record television programming was a fair use. And the court there told us that the technology was capable of commercially significant non-infringing uses. And that question, I think Sony's, it hasn't been overruled, obviously, but it's not it's been distinguished. But I do think that this capable of commercially significant non-infringing uses is now, is still a concern by the courts. It's just being captured in the discussion of whether or not there's a public benefit to the use, which is something that's taken up in the fourth fair use factor analysis. In 2005, we saw the Grokster case where Grokster was liable for copyright infringement via the contributory and vicarious infringement doctrines, distinguished Sony again. There, though I think the Grokster case is important in the cases that we're seeing come down because of its strong position with respect to piracy and theft, particularly in the Bart's case. The issue of piracy was paramount to that court, and the issue of good faith or bad faith is an unsettled area in, fair use doctrine, because there's a question of whether or not it should be encapsulated within the character of the use, right? Did you use it in good faith or not? And we've gone, at least in the Ninth Circuit, here in the Ninth Circuit, this is an unsettled question. But you know, obtaining a work illegally from the outset and having your copy be an illegal copy and then using it to create a work, that was a very important fact to the Bart's case. It's also incidentally an important fact in international regulation with respect to AI. In the EU directive on this issue, for example, we see that the safe harbor that's created for data mining, using a lawful copy and making a lawful copy of something is a prerequisite to being able to take advantage of this safe harbor. So I do think that the court's understanding of piracy is an important piece of this going forward. And then, in the Oracle case, in Authors Guild versus Google, which is another case in the Second Circuit, um, you know, there was a fair use defense that was unanimously affirmed. The courts were in agreement, which is often not the case in fair use decisions. You see a flip-flop all the way up, which is, just shows just how hard these questions really are to grapple with. But for Google Books, the creation of the search functionality and the display of snippets is non-infringing fair use, and it's highly transformative. We see this, highly transformative, spectacularly so. We see that language coming out in the Bart's case and in the Kadri case as well, right? Using training LLMs or image generation models, whatever, using copyrighted works is a highly transformative use. And so what's going on there is we're seeing the market harm factor take center stage. And then, in Oracle, it was another of these flip-flop situations because the Supreme Court reverses the Federal Circuit and finds that Google's use of Oracle's code was fair. It was, the reimplementation of copied code was transformative because it, quote, furthered the development of new computer programs by enabling programmers to use existing skills in a new mobile platform. And then we get some language about fair use that is, it permits the courts to avoid the rigid application of the copyright statute when on occasion it would stifle the very creativity for which the law is designed to foster. And so, there we see, strong statement that technological innovation really does have a place, but is it tipping the scales too far? I think the Kadri and Bart's cases are telling us that, perhaps. In any event, the litigation landscape with respect to AI is changing all the time. I, like many of you, are probably, I'm deeply indebted to Professor Lee and his incredibly helpful and insightful website and newsletter that keeps me up to date on all of this. But this map, which he updated September 11th, shows that we've hit 51 AI cases here in the US. And there is another tracker that he's created for cases on abroad that I is too much for us to discuss here. So only 3 of these cases that I'm aware of have issued a ruling on fair use. And so the first was the Thomson Reuters case, where the District Court of Delaware found that Ross infringed um, Thomson Reuters copyrights and that the fair use defense does not apply, right? Reuters, who owns Westlaw, sued Ross for using all of Westlaw's headnotes. Um, the summaries of key points of law and case holdings that exist to train a competing AI-driven legal research search engine. Importantly, this new product that Ross has developed is not generative AI. So it's not creating new material from what it was trained on. It operates a little bit differently on a technical level. So then that's an important distinction here. So with the first fair use factor, the court found that Ross's use was for a really similar purpose. It was a commercial use and it wasn't transformative. It's not generative, right? It's so the first factor went to Westlaw. The fourth factor also went to Westlaw. It's, the derivative market for AI training purposes is harmed. And Ross also meant to compete with Westlaw by creating a direct market substitute, which is the harm that is protectable. Um, under the Copyright Act here, even in the context of a fair use defense. So this case I mentioned is distinguishable. Ross's AI is not generative. It's, reproducing more of Westlaw's original. And, the headnotes themselves were considered original and therefore warranting of copyright protection. That was an issue in that case, that the copyright registrations weren't necessarily valid, but the court found they were. So the Bart's case, involves Anthropic's LLM Claude and its various incarnations. And as I've alluded to, this case makes a strong distinction between the library copies that Anthropic purchased. So they actually, bought a bunch of books and took them apart and scanned them. And then they also pirated a bunch of libraries. And the court evaluates the fair use defense for these groups differently. And I think that that's really key. This, theft from the outset issue is, even in the first line of the decision, you'll see it. It is very important to the court if that happens. And so procedurally, this case is interesting because Anthropic moved for early summary judgment on its fair use defense before class certification. And so the decision is only going to bind those, parties that are involved in litigation, but not any of the members of the class that have yet to be certified. And so strategically, that's an interesting maneuver, one that we see also done in the Kadri case, where both parties move for summary judgment and before class certification. So with respect to the first fair use factor, the first fair use factor favors Anthropic's lawful copying, right? The purpose and character of using the works to train the LLMs and to train Claude was transformative, spectacularly so. But this doesn't excuse the pirated library copies, right? And it's pretty important to the Bard's court. And it's interesting because this issue is not important to the Kadri court. And, it's just, it's fair use is thorny, like I said. But so the use of the books at issue to train Claude was exceedingly transformative and was a fair use under the Copyright Act. But piracy, but piracy of otherwise available copies is inherently irredeemably infringing, the court tells us, even if the pirated copies are immediately used for the transformative use and immediately discarded. So you can't get around a finding of infringement if you've started with pirated copies, no matter how transformative your use is, according to this court. Um, the Bart's court goes on to distinguish the Google Books case, where they're saying, look, the university libraries and Google went to exceedingly great lengths to ensure that all copies were secured against unauthorized uses, and that didn't happen here. So the first fair use factor points against fair use for the central library copies made from pirated sources. And no damages from pirating copies could be undone by later paying for copies of the same works. And I think that this distinction between the pirated versus lawfully obtained copies in the Bart's case really drove the settlement there. That's my take, because it's irredeemably infringing. The court tells us that, and so if you were Anthropic, anyway, it's an interesting question. So with respect to the fourth fair use factor, it also favors Anthropic. And the Bart's court's not concerned with this market dilution, indirect harm that the Copyright Office report raises. They're just not concerned about it at all and tell us that that's not the kind of competitive or creative displacement that concerns the Copyright Act. And so there, the court seems to really be going back to the idea that, not all harms are actionable harms. It's only this market substitution issue. So that brings us to the Kadri case, which was, judges right down the hall from each other, issued a couple days apart. So this case comes out in 2023. A group of book authors, I think 13 of them, sues Meta and its open source LLM Llama in Llama's incarnations. So again, they use this procedural device of making summary judgment motions early before class certification. So the decision only binds the 13 authors who, are the named plaintiffs. So the Kadri case is really different. The decision is really different than the Bart's case, and I think they're really, helpful to read together. If a little confusing, to see, what we can learn for, moving forward. But the Kadri court emphasizes that if a fair use defense fails, the consequence isn't an injunction, right? So, like, not like carry you, but instead a payment. The defendant will only be forced to stop what they're doing if they're unwilling or unable to pay for the right to do it. So the Kadri court also doesn't really think that it's reasonable. I think that the court calls it nonsense that, AI companies wouldn't be able to develop the technology if they were, required to license all of the copyrighted works. The court thinks that's silly. They're making billions of dollars. Like, come on, some of it can go to these rights holders if their contributions are really as crucial as, as you say. With respect to the burden of proof, the court, as we'll see when we talk about the market harm factor, the fourth fair use factor, the court, spends a significant amount of time criticizing the plaintiffs for failing to develop this adequate market harm claim and provides essentially a blueprint for the next plaintiff. Right. It seems to acknowledge the criticism, though, and goes on about the burden of proof and identifies that, the rights holder doesn't have to prove or present evidence of market harm, but they do bear some initial burden of identifying relevant markets, and that's emphasized in the case. And so I think at root, the Kadri court is looking at the underlying incentive to create and looking at the purpose of copyright under the IP clause of the Constitution, and concludes that flooding the market with Gen AI created works is going to dramatically undermine the incentive for human beings to create the old-fashioned way, is what the court says. And to me, Gen AI tools are tools, and people who are creators are going to be using these tools to create. So I don't know that this ruling really encapsulates that nuance, but with respect to the first fair use factor, again, no serious question highly transformative. And that makes sense. The court also addresses the shadow library issue here and raises the unsettled, good faith, bad faith distinction, but doesn't really find it super relevant that a lot of this stuff is pirated, based on case law, because the whole point of the fair use analysis is to determine whether a given act of copying was unlawful. So it doesn't really matter where you got it. I don't know if I agree. I mean, the Bart's, I don't know. I leave it to you all to think about that. With respect to the fourth fair use factor, the court plainly sees that this factor should go to the authors, but finds for Meta anyway. Um, so this is where, the court emphasizes that the relevant market harm includes indirect market substitution, which is this idea from the Copyright Office draft report. Flooding the market indirectly substitutes for the originals, and then people are going to be disincentivized to create, right? The example used in the cases, Agatha Christie, the next Agatha Christie, I'll never bother to pick up a pen, I think the judge says. So the plaintiffs in Kadri focus their arguments on, the harm to the author's licensing market and don't really touch this totally novel indirect harm because of market dilution issue that's raised. And so, to my mind, this ultimately almost seems like an advisory opinion to a certain extent, at least this portion of it, because, the court's talking about a hypothetical plaintiff who, could raise this, and this is how you should do it. So I think that's really, really, really interesting. And the, other members of this class who, have not, been certified yet and who can bring claims against Meta will be able to take this and go running with it. But too bad, so sad for the 13 who lost on summary judgment because they, I guess, didn't identify the relevant market with sufficient specificity to the court. So this, in terms of going forward, is a very strong statement that, market dilution will cause plaintiffs to decisively win the fourth factor and thus win the fair use question overall. Right. So I mean, that tells us which way this court believes this issue is going to go. And to me, I will leave you with, a quote by Sam Altman, who tells us, I think he did a TED talk in the spring that I watched, and I pulled this from there, that we need to figure out some kind of new model around economics of creative output. And I think to a certain extent that's true. Like, is fair use the best place to be resolving these, crucial issues? Is regulation in order? Is some kind of industry agreement, right? Professional associations. I don't know the answer. I just leave you with the question because I don't, it seems like a very thorny area of law, a very unsettled area of law to leave these big questions. So with that, if you have any questions, I would love to hear from you. And in the couple minutes that we have, I'd love to answer any questions that are in the chat.
All right. We currently don't have any questions just yet, but we'll allow a minute or two for that to go about. Do you have any more closing remarks or important tips to remember?
I just, I'm thankful to be here and I appreciate all of your attention. And, I would love to spend some time talking about these issues with you, in the future. It's something that's developing and changing all the time. And I think we're really going to be seeing a lot more activity in this area. And hopefully, the more we, talk with each other and learn about these issues, more answers will come.
All right. It looks like Marina Bagurad is asking, can you comment on the settlement in the Claude case?
Yeah, I do think that the settlement there, I think it's related to this piracy issue, right? This irredeemable infringement perspective that the court seems to have, right? And I think it's interesting that the court's not approving the settlement because it's going to bind the class members who are not, who were not involved in the summary judgment motion. Um, but I haven't checked into it today, but I do think it's going to be very interesting to see how that plays out. But I don't know that Meta would have made the same decision if, because the decision in Kadri is just so divergent from the Bart's case, and the role of the pirated libraries or the shadow libraries is so crucial in the one, and not very relevant in the other.
Great, thank you. It looks like Cedar Oshan is asking, further to the economic model, the license deals are using digital proxies to allocate license fees to works. Do you have thoughts on appropriate digital proxy methodology?
I don't, because I will have to drill down on this. But if you want to reach out and tell me more about it, I would love to give you an informed opinion when I form one, but I don't have one right at this moment.
Okay, let's see.
Oh, Bianca, the Sam Altman quote is from his TED Talk. You can find it on YouTube. But I think my slides will be available sometime soon. I didn't make them quick enough for them to be posted before the presentation, but you should be able to find it there too. But it is on YouTube if you look for his TED Talk from the spring. I think April, maybe. Am I familiar with a case similar to the Meta case where authors have successfully articulated the relevant market that was harmed? No, we haven't seen that yet. At least as far as I know, and maybe Professor Lee could jump in and tell us if there's another case. I know that the studios have just jumped into the fray, in bringing AI cases, but this market harm issue, this indirect market harm via dilution, is not something that we've seen in case law before. It's something that I think comes up for the first time really, clearly in the Copyright Office draft report, and was expounded upon at length in Kadri. Plaintiffs who are suing Meta after the Kadri decision will obviously make this argument, but we haven't seen it yet because we're not too far in those cases yet. Um, how am I advising my artist clients with respect to this issue? Watermarks. If you put something, if you put something online that's your creative work, especially if it's a visual work, watermarks are like incredibly thorny problems for training purposes, and your work will probably get filtered out because of watermarks. So I would use watermarks. I would share sparingly, and I would make robust use of contract law wherever possible to make sure that you're prohibiting distribution beyond what you want. And so that's not the greatest answer because things get stolen, as we see. But those are some broad strokes recommendations. Suzanne, are there other questions that you see?
Let's see. See, I do see some.
Oh, here's one about laws, regulations. So I don't know. I think we're over time. So Suzanne, please tell me if we should shut
No,
it down.
no, we're good on time. We have a couple minutes, actually. We have
Okay.
about 7 minutes left, so we can
Oh, okay, great.
dig into things.
So what kinds of laws are being drafted to control how AI is developed? So the regulatory side of this is very interesting. And so I mean, a huge amount of laws have been introduced on the state level. And some of them are passed and some of them are not, but when you compare the number of bills that have been introduced to the number of laws that have been enacted, it's very different, right? So there's a lot of ideas, but there's not a lot of concrete determination on what we want to do. There's also been a statement that was in a bill on the federal level, and I honestly don't know what happened with it because there's so many things to follow lately. But there was the idea that maybe we shouldn't pass any laws about AI for the next 10 years, is what I recall. And that was coming from the federal side of things, which would prohibit, obviously, under the Supremacy Clause, the ability for states to legislate in this area if they wanted to. And so I don't think that was made law, but it's been an idea that's tossed around. We see a lot more regulatory action in the international context, in the EU, in the UK, and Japan. We see that there's a lot more activity on the regulatory side, and there's kind of safe harbor carve outs that if you adhere to certain things, then as a, an AI company, you can take advantage of those safe harbors. But lawful copying is one, requirement to taking advantage of those safe harbors. At the end of the Copyright Office draft report is an overview of the international landscape, which includes a lot of information about regulatory issues. Let's see. There's another question about a licensing of content for uses AI training data. Yes. The courts are at least the cadre and the Bart's courts diverge about the availability of licensing content for AI training purposes. There is case law in the fair use context that says that, look, if someone's making a transformative use of your work, a plaintiff is always going to lose the right to license to that particular defendant if a fair use decision is found. So, in order to avoid the market harm factor as becoming circular, it's necessary to acknowledge that the plaintiff is always going to lose that licensing revenue, but that's not, the relevant harm here. And that's really interesting. And I think that that's discussed more at length in the Kadri case, I think. But it is an interesting question. It's also clear that there is a market for this developing. It's been developing, and there's a lot of interest in licensing, and there's AI models that use clean data. Getty Images has entered into a licensing agreement for its content. I think The Atlantic entered into a licensing agreement for, to license its content for AI training purposes. And um, you know, the Copyright Office's report makes clear that, they really do feel like we should let this market develop. There's definitely the opinion in the report that, as stated by all of the stakeholders who responded to the notice of inquiry, that compulsory licenses are a terrible idea and we shouldn't do that. And that there is this growing market for, licensing copyrighted content for AI training purposes. In the image space, it seems clear that copying all the images on the internet and doesn't give you as good of a, generative model as highly curated data sets of images. And so with respect to images, it seems like the licensing market will develop on its own because the quality of your model is really going to be dependent upon what you're putting into it is, in this particular space. So I don't know that that's the case with large language models where it does seem clear that the more stuff you feed the trainer, the model for training purposes, the better output you get, right? But for images, that doesn't seem to be the case right now. Curious if I predict a circuit split. Think the Second Circuit has been pretty slapped down when it comes to its fair use jurisprudence, and really tried to course correct with Warhol. The Ninth Circuit is kind of always a crapshoot. I could never predict what's going to happen in our courts. California is just so wonky. I imagine that we're going to see. I mean, I guess I'll say this: given the difference of opinion with two judges who are literally right down the hall from each other in the Northern District of California, I think the chances are pretty good that there will be a circuit split on these issues, and how the Supreme Court chooses to resolve the questions here is anybody's guess. Um, let's see. Can we create laws so that AI technology must be developed in such a way as to create tags for all copyrighted materials used so as to provide protection? That's such an interesting idea. I love that. And in the art context, that's something that had been attempted to be done using blockchain technology for authentication and provenance purposes, right? Like the chain of title of an artwork. And the market itself was really resistant to that idea. Um, I think this will impact anonymity with respect to creating works, and um, people might not want to be associated with particular content. Sometimes yes, and sometimes no. So I do think that's an interesting question, and there is ways to create tags in a certain sense, right? You have metadata, you have watermarks, you have other ways to identify material as yours, but the models are getting better and better at filtering all of that out. One of the issues that we see in the copyright cases, which claims that have not been dismissed and were not at issue on summary judgment, are the the automated removal of content management information. So I think if we created tags to provide protection, the models would be, moving in a direction of trying to automate and remove those tags, unless there was some kind of agreement in place as to a revenue sharing method, kind of like what Sam Altman seemed to be talking about in the TED Talk. But let's see. If technology was regulated to the point that copyrighted materials used to feed AI algorithms is developed, then it may help solve the problem. Yes, maybe. And this is where we need a data scientist to help us, because, art law only takes me so far with respect to this. And I'm curious. I love learning about all this stuff, but I'm certainly not an expert when it comes to the mechanics of the models. Should AI companies be treated as publishers or social media platforms under Section 230 of the Communications Decency Act? That's a good question too. Uh, my initial thought, I've never thought about this before, so don't hold me to this, anyone who's listening, but my initial thought is that the models are creating new content, right? The safe harbor of Section 230 is really for people uploading copyrighted works, and you as an ISP, you're not aware of that, right? So you can't necessarily be held liable for reproducing copyrighted content and infringing, because you're not the one who's actually uploading it. But here, the models that the product that's providing content to the public, this the generative information that's coming from the model to a user is not going to be that copyrighted content. At the beginning of of these cases, and when this first became an issue in the law, there was a lot of discussion of infringement on the input side and infringement on the output side. And with respect to infringement on the input side, right, the wholesale copying for training purposes, that's what we're looking at now. Because it seems like plaintiffs have, you know, I won't say largely abandoned, but have put the issue of the output to the side. And I think in tandem, um, the technology is developing to include more significant guardrails than there were in the beginning. I think there was that Getty case where the output of, I don't remember if it was Midjourney or DALL-E, which has now been folded into ChatGPT, but the output was like including Getty's watermark on like a picture of a soccer player. It was in the complaint. And so there, I think that that's not happening anymore to a certain extent. So the rationale behind treating publishers or ISPs, and giving them a safe harbor under Section 230 is being mitigated because none of the copyrighted content is being reproduced on the output side. Let's see. I think many judges see AI scraping to be no different than what artists have done for centuries, but now at an unprecedented level. Yes, I think you're right. And there's a debate between the judges in the Bard's case and the Kadri case on precisely that issue, right? Like the Bard's judge is saying, look, this is no different than like school children reading all these books and an explosion of new works that are competing with the ones that they learned on. But I think that the Kadri court makes a lot of good points that, this is really distinguishable. And the way that, a model is learning is totally different than the way that the human brain is learning. And that, it's apples and oranges to a certain extent. Um, I do, however, keep in mind that, I think it was Picasso, but it could have been Bob Dylan. I really don't recall, but good artists quote and great artists steal, right? So I do think that that's true that for centuries we've built on the innovations of others, just like I've built on the innovations of all of the, contributors to the Beverly Hills bars, learning on this subject, right? We're all learning from each other, but the models are not learning like that there, and then that brings me back to that kind of statistical similarity issue, right, where the copying on that level is really the granular actual expression, right, how you're choosing to put these things together. Artists, you know in large part are copying ideas, which are not protectable anyway under the idea expression dichotomy, right? What the models are doing to a certain degree is copying the actual expression, the original expression. And so I do think that is a little bit more nuanced than maybe the judge in the Bart's case, for example, was thinking about it. And then I think this is the last question. So that law is developed so that mandates that AI technology be developed so that all copyrighted materials that are used to feed AI algorithms have unique tags attached to them or that are automatically attached by the AI technology or oh, I see. You're just clarifying. So I don't understand what you mean, Miriam. I'm so sorry. I wish I did, because I'm not totally following this, and I wish that I could in this moment because I would love to answer and clarify for you to the extent that I have a position on that. Um, but I don't know that we could ever require authors to include specific content with their works. I think that might be abhorrent to the First Amendment. But in any event, okay, Miriam, you're telling me that I already answered it. Okay, great, great, great. So perfect. Suzanne, I will leave it to you if there's any other questions or issues that we should talk about before we all part ways.
All right. Well, it looks like this concludes today's presentation. Thank you so much, Amy, for your time, and thank you so much to our audience for joining us today. Have a great day, everybody.